Welcome everyone to the Whitlam Institute for this In Conversation event with Emeritus Professor Jenny Hocking. My name is Leanne Smith and I'm the Director of the Whitlam Institute. As many of you would know, this week is NAIDOC week, and although many events have been postponed due to COVID, I'm reminded today of Gough Whitlam's warning to us 48 years ago when he was outlining his policy platform for Aboriginal and Torres Strait Islander self-determination. Gough Whitlam said, and I quote, "All of us as Australians are diminished when they are denied their rightful place in this nation." And I think all these years later, this statement is as true today as it was then. I'd like to acknowledge that I'm joining you today from what was and always will be Gadigal Wongal land and pay my respects to elders past and present. And I'd like to make a special welcome to First Nations people who may be with us today. Now, I suspect that some of our audience were at the very last public event that we held at the Whitlam Institute on the 7th of March. It was a sunny Saturday afternoon, just before the chaos erupted. And we had Jenny at the Female Orphan School speaking to a full house about the Palace Papers case before we knew the outcome of the High Court appeal decision. It was a wonderful session, and I encourage you to watch the video of that event on our website if you haven't already. Of course, the discussion today will certainly add to and complement Jenny's last engagement with us. So for those of you who might be new to this topic and who might be new to Jenny's work, please allow me to start off now by just giving a brief introduction to Jenny. Jenny Hocking is an award-winning biographer and academic. She was the inaugural Distinguished Fellow for the Whitlam Institute, and she's Emeritus Professor at Monash University. Jenny is the author of 3 biographies, including the acclaimed 2-volume biography of Gough Whitlam called Gough Whitlam, A Moment in History from 2008, and Gough Whitlam, His Time from 2012. Jenny won the Fellowship of Australian Writers Barbara Ramsden Award, and she was shortlisted for several awards, including the Prime Minister's Literary Award, the Age Book of the Year, and the National Biography Award. Her latest book, so far, is the Dismissal dossier, Everything You Were Never Meant to Know About November 1975, The Palace Connection, which was published in 2017. But her book about the campaign to release the Palace Letters, which will be aptly titled The Palace Letters, is due to be published by Scribe in November this year. Jenny Hocking is also on the National Committee of the Australian Republican Movement, and I know that she had a session with the ARM not so long ago. So just in terms of how this webinar will proceed, I wanted to let you know that we've scheduled an hour and a half for our discussion today. And we'll start off with some questions that I've put together for Jenny and then open the floor to questions from you, the audience. We have over 400 people registered for the discussion today, so please do bear with us as we collect questions and feedback, and I'll get to as many of those questions as we can. For this particular webinar, we'd like to invite you to share your questions through the Q&A button on your Zoom screen rather than the chat button. That's how we'll be taking questions today. So Jenny, if you're ready to go, shall I get started with the first? Great.
Yeah.
Fantastic. So Jenny, many of the people in our audience today will have been following the Palace Papers case, but for those who might not have been, do you think you could start off by giving us a sense of where this all started and how you got to this point?
Well, in terms of the case, thanks, Leanne, thanks for the very warm introduction, and I thank everybody for coming today. It's really terrific. In terms of the case itself, it began 4 years ago with a challenge in the federal court challenging the description of the Palace Letters as personal records. And I want to make it very clear from the outset that this has been an extraordinary team effort. It could never have happened if I didn't have the extraordinary pro bono legal support from Anthony Whitlam QC, who took the case at the federal court, from Brett Walker SC, who took the case at the appeal and then at the High Court, and with Tom Brennan, who worked on the case throughout and were instructed by Cause Chambers Westgarth. It was an amazing legal team, all of whom worked on a pro bono basis. And at the same time, I had a fundraising, a crowdfunded campaign called Release the Palace Letters. And so many hundreds of people contributed to that. sent me words of encouragement, followed the case every day, every step of the way. And it's really unusual for a case that's crowdsourced, but also crowdfunded, but also pro bono legal support all the way to the High Court of Australia. So that has been a wonderful campaign and a wonderful, fascinating journey through the courts. And of course, the outcome has been very, very good as well. So that's the immediate fact of the case. But in many ways, the case began in the broader sense long before that, because I think it began 10 years ago in Sir John Kerr's private papers in the National Archives, because it was there when I was doing research in Kerr's archives for Whitlam's biography that I first came across the palace letters as documents within Kerr's own holdings. And, you know, the context of this is that Kerr's papers had been the most dramatic and fascinating and important set of historical documents. It was only because of access to Kerr's papers in the archives that some of the revelations that have really dramatically transformed our understanding of the dismissal even came to light. Many of you would be familiar with the revelation of Sir Anthony Mason's role in the dismissal, the High Court Justice who met with Kerr in secret for many months, as Kerr said, acting as his guide and confidant, and who helped write the letter of dismissal for Kerr. A very active role and one that was kept hidden from Australian people for 37 years. Other documents in Kerr's papers pointed very clearly to a much stronger role of the palace, and in particular of the Queen's private secretary, Sir Martin Charteris, than we'd ever been led to believe before. They show that Kerr makes a note of what he calls Sir Martin Charteris's advice to me on dismissal. Now, that's a really strong statement, that he was in touch with Charteris, the Queen's private secretary, about matters relating to the dismissal. It's also clear from his records that he quotes from many of the letters. There are extracts from the letters. So I began to get a picture of what the letters might tell us, but also of just how important they were. And so obviously I made every effort I could to access the letters. I tried to access them from the archives at the time and was told that as personal documents, they did not come under the Archives Act and were not available to view. So given the cost and the prohibitive nature of taking a federal court case, which that would have entailed, that was something I just had to leave aside for the next 5 or 6 years until a series of conversations led to the suggestion of a possible court action. So it has a long background and a more recent legal history, and it's a wonderful thing that they've now been released.
It's been an incredibly long journey for you and for those of your supporters who've been following your efforts towards this point. I think a lot of people would like to know, after this decade-long struggle, how are you feeling at this point where you've invested so much energy? There's obviously been a strong sense of exhilaration, but we've got the High Court decision now, but not access yet. So how does that leave you personally and as a historian?
Oh, look, I'm still feeling absolutely delighted and to some extent exhilarated, because, you know, regardless of what happens at the moment, and we have had some time now since the decision's been about 6 weeks, and there have been some delays and so on. These are relatively minor matters compared to the really big question, which was fundamentally what was considered as a question of law. And that was the quite extraordinary view that letters between a Queen and a Governor-General, the two positions at the apex of a constitutional monarchy, could be described as personal and therefore hidden from public view, as they were. They were under the Queen's embargo. So I think the really big, obviously the very big stumbling block, the big hurdle was the law, and to have succeeded on that level means that these are now recognised as Commonwealth records, and that means they come under the Archives Act, which means there's an open access provision after what was then 30 years. So there's no doubt the letters have to be released. Whether they're released entirely or with redactions is something the archives are currently working on. I have very strong views about the prospect of any possible redactions and feel that there should not be any for a number of reasons, which we can go into later. But I do think that where we are at the moment is frankly a wonderful position, because I never imagined 4 or 5 or even 2 years ago that we might be today talking about the prospect of looking at these letters. They are just so historically tremendously significant. They will recount what was being said between our Governor-General and the Queen of Australia, at what the Federal Court described as the most tumultuous period in the nation's political history. And that was the unprecedented use by Kerr of the reserve powers, themselves extremely contentious and in many respects antithetical to democratic practice, powers in the name of the Queen, of course, in removing the elected government from office. So they're magnificently important documents, and regardless of whether we have to wait another month, another 2 months, I think the takeout from this is that they are now recognised as public documents. It's a pity that for the last 40, 50 years they've been described as personal documents and kept hidden from view under the embargo of the Queen, but it's a wonderful thing that we can now view them.
I know, it's fantastic. Jenny, the High Court decision, the judgment, is 111 pages long. So some of our audience may not have read the full set of judgments. And I wondered whether, aside from, the essential element of these papers being Commonwealth records, not personal, there were any other aspects of the judgment that you'd like that you found important, both as a historian and as we go forward.
Yeah, look, it is a really important and significant judgment, Leanne, and I think it'll take some time for the import of that judgment to be fully analysed, because while the case was obviously very specifically around the particular circumstances of these letters, the way in which they came into being, and even in terms of the notion of Commonwealth record, how that was assessed by the court is quite specific to this case. But the implications of it are nevertheless very strong, I think, for all Governor-General's records, and there are several kept in the archives. There are strong implications for state governors' records with the palace, because they've all been kept under this same notion of, if you like, royal secrecy, what was called in the court the Convention of Royal Secrecy. So a couple of things that are really important about this case. It was a landmark case because of the simple reason that the Archives Act, in the way it defines Commonwealth record, had never been tested before in the court. And what this has done is confirmed by the court that the Commonwealth record notion does include records of the Governor-General in general, but also Governor-General's correspondence with the Queen. So that's absolutely critical. But beyond that, a very strong argument put by the Archives legal team was that we had to respect what they called a Convention of Royal Secrecy, and that this had to match what was done in the UK. And the alarming notion about that is that it's a really effective way of simply keeping any royal material out of public hands through a claimed convention. I mean, it was even elevated at one point to a constitutional convention of royal secrecy, which I found rather interesting in the Australian context. But so I'm very glad that the High Court has dealt with that and quite explicitly ended what could have been seen as a sort of reflexive deference to royal wishes, because after all, it was the Queen's embargo that was keeping material in our own national archives from us. So that's a really important part of the judgment. Several judgments, there are 3 judgments and 6 justices all in our favour. And I'll point in particular to a couple of paragraphs in the majority judgment, which is the Chief Justice and 3 others. And they make a very strong point, and it gets to the question of redactions. And that is a very strong point for those of you who are interested in looking at its paragraphs 121 and 122, which get to the question of whether the fact that this judgment will actually go against the wishes of the Queen, will actually go against the wishes of and expectations of the Queen's private secretary. It goes against the wishes and expectations of the then Prime Minister Malcolm Fraser, the then Official Secretary, Mr. David Smith. And it's very important that the court actually recognises that and says that is because the wishes of the monarch do not hold. The wishes of the monarch cannot overturn the legislative requirements of the Archives Act. And I and a couple of others, Richard Ackland in Justinian recently, pointed to that same section and said it's remarkable that in the 21st century we have to remind ourselves that the wishes of the Queen do not hold and that our legislative process and our laws hold. So this is a very strong comment, not one that's been picked up widely, but that I think is significant not only for this case, but also going forward for the questions of redactions, because it is clear that the High Court is saying that the wishes of and the views of Buckingham Palace ought to have, and Government House ought to have, no say in the questions of control and access to these letters.
Mm. So Jenny, we're all awaiting the content of those letters, hopefully soon. Some commentators have seen in the media have predicted that there'll be nothing of substance in the papers anyway, nothing that would definitively establish that the royal family played any role in the removal of a democratically elected Australian Prime Minister. Given what you know about the letters at this stage, what do you make of such a prediction, if you can gaze in that crystal ball?
Well, it is a crystal ball, and that's the first thing I'd say, is that we haven't seen the letters. So in terms of making predictions about what they may or may not say, it's really important to base that on what we have seen and what we already know, some of which I've mentioned. But some of the things that came out during the course of the case, which I think have been just as significant as the finding of the court itself, have also added to what we know about the letters. And I think certainly going on what we know from Kerr's papers, not just from what he says about the letters and what they've revealed, but also from other material in his letters, and in particular comments he makes to others that he is writing to, where he reports on his correspondence with the Queen. He makes it very clear that he is letting the palace know, at the very least, of the possibility that he may move to dismiss the government. And he, in fact, writes of what he calls his concern that he will be recalled from office by Gough Whitlam if Gough Whitlam discovers that he is, in fact, considering going down that path. The really critical context here is that at the time Kerr is engaging with these quite extraordinary, politically explosive communications with the palace and with the Queen, he is keeping silent to the Prime Minister, Gough Whitlam, and he makes no bones about that. Kerr is very open about that. That's one of the few things he is actually open about, when he says to various people and in his memoirs that he decided on what he calls a policy of silence to his own Prime Minister, the elected government, head of elected government, to whose advice he must ordinarily take. So it's an extraordinary situation where he is failing to take advice to advise himself to discuss openly with the Prime Minister options available to him, and instead appears, certainly from the material we've already seen from Kerr's archives, to have been remarkably open with the Queen, and certainly and in particular with the Queen's private secretary. At one point, Kerr refers in one of his letters to a colleague, he refers to what he calls the illuminating observations of the Queen's private secretary, Sir Martin Charteris, at the time. So the fact that, and he says, I took great comfort from those illuminating observations. And that tells you immediately that these were not just the sort of ordinary rote dispatches between a Governor-General and a monarch that might have been the usual process prior to 1975, but that these were letters in which deep discussions were actually being had. And I should also point out that one of the things that came out during the course of the case that is so critical to understanding what the letters will say and how to understand them was material about the nature of the letters. One of those, and the single most important detail, was just how many letters there are. There are literally hundreds of these letters, and that is absolutely staggering. Governors-General previously had reported regularly back to the palace, at most 4 times a year, quarterly. So the extraordinary thing is here that we have over 100 letters from Sir John Kerr to the Queen over the period of his term in office, just over 3 years, and about 196, I think, letters back to Sir John Kerr from the Queen. So this makes it a staggering group of letters. Kerr also attached many extensive attachments to his letters, other people's letters, details of press reports at the time, journal articles and so on. And they are going to be just as important again in understanding what sort of detail and what sort of information, and whether it was polarised and partisan information that he was passing on to the Queen. So given the nature of the letters, and the fact that one other point that was revealed during the course of the case is that the Queen's letters back to Kerr actually reflect the views and thoughts of the Queen to the Governor-General. So there is no doubt that this is detail about what the Queen was thinking at the time moving towards the crisis that was occurring in government in Australia. It gives the lie completely to the constant refrain that the monarchy is above politics, that the monarchy and the monarch are neutral, politically neutral, and do not become engaged. Because in my view, Kerr has already made them involved. He has involved them in his thinking, his consideration of the direction he might go, and the way in which he interpreted those letters has played a central role in his comfort and willingness to then dismiss the government without warning.
Mm. So Jenny, that leads nicely to the next question I wanted to ask you. So in your long-running search for the truth about the dismissal, I'm interested to understand, as a historian, have you been more motivated by the need for transparency in decision-making and in timely access to historical records? Or have you been more motivated by the substantive impact of the idea of potential external interference by a foreign power in Australia's democracy? Or do they blend for you?
Well, look, to some extent they blend, Leanne, but I think really at base, as a historian, the fact that such critical archival materials is blocked to us, and blocked to us, as I keep saying, because it is extraordinary, on the embargo of the Queen, and yet they are sitting in our own archives in Canberra. That's what motivated me. If ever there was going to be an opportunity to read those documents and to understand their significance, of course, that was something that I was always going to take if it was at all possible. That's what drove this case. Of course, there's an essential element of what the letters actually say, but to some extent, I'm far less interested in what they say than the fact that we need to be able to know what they say. Mm-hmm. It was simply intolerable, I think, certainly as a historian, but also as an Australian, that we were not able to view our own really significant national archival documents, and particularly in the context of such a significant part of our history. So my work has always been driven very much by archival research. I happen to enjoy archival research. There's a significant amount of material in the Whitlam biographies and in all the works I've done over the years. There have been other works apart from the biographies in another field, but they've all relied to some extent, or at least developed out of, original archival research, because history is a dynamic process, and there's nothing more dynamic than the history of the dismissal, where things emerge from different researchers, that the different individuals involved gave sort of lengthy interviews revealing material that they kept hidden for decades in a sort of last-ditch attempt at some sort of redemption. And all of these things have only recently been opened, and they have added to our understanding greatly. So I can't stress more strongly just how important archival holdings are to history, but not only the holdings themselves, but access. There's no point having the best holdings in the world, the most complete holdings in the world, if we cannot access them. And so this fundamental question of our inability to access records, again, it's a marvellous thing that has been dealt with by the court, because I see access as the sort of hinge, it's a pivot between a secret document and the passing of that document through public access, into the public domain. And it's because of that process that we can then incorporate the document and what it tells us into history. So we need to make sure, and this is why I take a very strong view about redactions, we need to make sure that the process of access is indeed as public and as open and as transparent as it possibly could be, so that whatever the records tell us, we can recognise it in history. I've always had the view that we have nothing to fear from knowledge in history. It's what makes history so fascinating. It's what makes it rich and a story and full of errors and successes and all of those things. But if you can't access the documents that tell you that, and tell you where perhaps people went wrong and should have done things differently, then we can't learn from it and we can't benefit from it. But we also can't enjoy it because it comes across as staid, partisan, as incomplete. And so I certainly hope that we can access all of these letters and make them a part and an understanding of our history.
Mm. How do we do that, Jenny? As a historian, you know, history's been told in this country in a certain way for a long time now. How do we go about correcting and if you like, rewriting this period of Australian history?
Well, it's exactly that. It's exactly what you say, that it is a process of rewriting and reconsideration. And I think the letters and the journey to get the letters is so important and so has revealed so much. And I'm sure the letters will become a part of that, that it really does mean that all of the histories that we have had to date will need to be revisited with that in mind. And that's the process and the dynamic of a written history, as opposed to the sort of the history as lived at the time, because, and particularly so for the Whitlam dismissal. I mean, I think what it points to and what it reminds us of is just how flawed the history has been, because we've almost had both hands tied behind our backs for so long, for many years, really until Kerr's papers were opened and we realised the extent of the subterfuge, the secrecy, but also the distortion and some of the really disturbing things that have been revealed along the way are outright falsehoods about the involvement of others in the dismissal that we'd been led to believe was not the case. And you know, just one example is some letters between Sir John Kerr and Garfield Barwick, formerly the Chief Justice of Australia, some years after the dismissal, talking freely, coincidentally on the anniversary of the dismissal, about 7 years after the dismissal, where they quite freely talk about the fact that Sir Anthony Mason's name was not known to history, was not public, and how long it would be before they decided to make it known, as if it was their decision to allow us to know our own history. And I found that frankly quite appalling, but it was an indication of how many secrets there were about the dismissal. So what we find, I think, is that the Palace letters are one of a long line of materials that have been kept from the Australian people. The prior involvement of Malcolm Fraser and Sir John Kerr speaking together before the dismissal, which they'd always publicly denied, later came out. And it's a terrible travesty, I think, that figures involved in our public life and have such standing in our public life decided that they would not only deceive the government of the day, but that they would deceive the history that then was written about that period. So the release of the letters, I think, will be certainly one of the last remaining great elements of secrecy in a long line of secret documents about the dismissal. And it will mean that the history from now on will have to take account of those letters, will have to incorporate those letters, and assessments that have been made about what happened in 1975 will need to be really seriously reconsidered.
Mm. We often talk about the fact that if we don't read history and understand history, we're likely to make the same mistakes again. And in several of the events that you've held for us, a number of audience members have asked really a question moving forward of, you know, regardless of what we find out, what more we find out about what happened in 1975, what does the outcome of this High Court case mean for the future of Australian democracy in the event that a scenario like this could appear again?
Look, I think there's a number of really good things going forward that have come out of this episode. Both, I won't say good things came out of 75 because, you know, it was a very difficult, traumatic time in so many ways, both for the institutions, but also for the individuals involved. But from what we now are knowing and understanding about it, you can look for a better way forward. I think one of the really strong points to make is that the release of the letters, together with the way in which we had to work to get them released, points to the lingering, what you might call post-colonial entanglements that still exist at an institutional level. And that certainly surprised me. I mean, and I'm sure it surprised many people to know that it was possible that the Queen could still, through some supposed convention of royal secrecy, have control over materials relating to an event that it would appear her and the palace at least had some prior knowledge of the possibility of. That's a concern. But what we now know is that we can work towards ensuring that doesn't happen again, to ensure that there is transparency over the actions of those at the highest level of governance, but that also point to the workings of the reserve powers. And I said earlier that there's a very strong sense in which the notion that a Governor-General can act alone without recourse to advice from an elected government or their Chief Minister, Chief Advisor, and take exceptional action in removing an elected government on their own volition under the name of reserve powers is quite frankly a shocking disavowal of an electoral process under the Westminster system. That's something we need to deal with. And I think we have to understand how that played out in terms of discussions between the Queen and the Queen's representative in Australia, who was taking that action of reserve powers without speaking to the Prime Minister about it and without warning the Prime Minister. So as far as I'm concerned, the only way to guarantee that there is no remaining entanglement of post-colonialism, what Whitlam called lingering colonial relics, is to actually sever those ties together. So for me, the future must be a Republican future, and one in which we stand alone, where this opportunity for secret discussions between a higher power, whether that be one in the turreted towers in a palace in England or the reserve powers of the Governor-General, is no longer available to us, and that the wishes of the elected government and the electorate through the House of Representatives is recognised. And so that's something I think we need to move forward on and to stand alone, which is really the only way in which both the events of 1975 and the problems we have had with accessing the royal history of those events highlights.
Mm. Jenny, I'm going to open to questions in a moment. I just had one last question, and it's more of a process question. Could you give us a sense of your understanding of what the process should be going forward in terms of accessing the papers now?
Yes, look, I've had discussions with David Trigger, who I understand is here today, and that's a terrific to welcome him here. David Trigger, Director General of the National Archives, about the process from here. And I understand that the archives are currently looking at possible exemptions which are available under the Act. And that's where the situation is. As I said, I feel very strongly, both in terms of the context of the court case, a 4-year struggle to release the letters, which found very strongly an emphatic decision, a 6-1 decision, that the archives' description of the letters as personal and as the basis for withholding them from the public was not correct, and has indicated that they are Commonwealth records. In the context of that emphatic court decision, together with the really important aspects of the judgments, some of which I referred to earlier about the fact that this decision does not reflect the wishes of the palace, I feel very strongly that there are minimal, if any, grounds for redactions. It's been 45 years since these events. History tells us that over time, the sorts of bases for redactions that are listed in the Act diminish with time, and certainly the judgments also make that very clear. So there are several points in the judgments where what they are saying actually has very strong bearing on the possibility or otherwise of redactions. And I think all Australians, after watching this case, feeling so strongly that these critical documents in our history ought to be released, feel equally strongly that there ought not to be redactions which in effect continue a process of hiding the history from us. And all I will say in relation to that is I understand that the archives have work to do on that. But I think one of the really critical questions, and unfortunately it's not one we've been able to have an answer to, is what other bodies are being consulted over this question of redactions? Because if, for example, those bodies might include, even indirectly, Buckingham Palace or Government House, in my view that would be completely inappropriate. Not only because of the comments from the judgments and from the High Court of Australia in those judgments, but also because both Buckingham Palace and Government House argued very strongly at the court through a submission given to the court at the federal court stage from Government House that the letters ought not to be released. Now, given that the Government House has made its views clear, and given that within that submission they included letters from Buckingham Palace, very kindly interpreting our own Archives Act to us as one that says the letters should not be released, thankfully the High Court has ruled that that is not the case. I feel it's completely inappropriate to involve either of those organisations, even indirectly, in any sort of discussion about what ought to be done with these letters after such a stunning High Court decision. So I have concerns. I've made my concerns very public. I'm very open about them. But that is a concern that we have transparency in the process through which the redactions are made, and as yet we do not, but also so that we have a transparency about the records themselves. Just one final point, Leanne, what has to happen with this is that the letters are open to the public once my case has been dealt with, once my application has been dealt with under the order of the High Court. And the file itself, which contains the letters, is to be an open document under the open access provisions. Now, any redactions that are made from that must be identified in that file. So if there's an entire letter removed, there must be a page indicating that. There must be a statement on that page as to which of the criteria have been used to redact, so that even if there's a name redacted, that process has to go through. So whatever is done to the file is yet to be seen, but if there are any redactions, they must be indicated, they must be notified in the file itself, and there must be a statement as to why. So that's the process going forward in terms of how we now start to look at the records.
Thank you, Jenny. And I wanted to acknowledge as well that David Fricker, the Director of the National Archives, is listening into the conversation today keenly. He's indicated publicly and to us in preparation for this event that the letters will be available very soon, certainly by the end of the month. And I just wanted to reiterate, if David wanted to make any comment or response in relation to the issues around redaction, would be very glad to invite him to participate in the conversation. But I'll just move now to some of the fascinating questions we've got coming in from participants. Maybe I'll start off, Jenny, with a great question from Esther Anatolitis, who has asked, well, she said, thanks so much for the valuable discussion. She has a question about Australia's more contemporary political culture of poor transparency. And as you know, Jenny, this is something that Brett Walker touched on in his Whitlam oration. She asks, how much has the release of the letters motivated real change in this area, both in legal terms, but also in cultural terms and public demand for transparency? Is there anything you wanted to say about the ramifications in this sense?
Look, I think a lot of that, and thanks for the question, that's a great question, will depend on how important the letters are historically. I think the more we realise that archives and the and in a government setting, not in the archival setting, but in the government setting, the move, which I think many people have documented, towards less and less openness in government that concerns many people at the moment, and questions around the right to know and the workings of freedom of information legislation and so on. I think that will be given I hope that will be given a renewed push by the opening of these letters, because the letters have become something of a sort of pivot point for understanding the significance and the meaning of the notion of right to know, right to access, and just how important they are for transparency of government and accountability of government actions. It's simply impossible to hold governments to account or organisations to account if we can't have access to the material that lets us do that. So I think the publicity and understanding and interest around the Palace Letters case has driven a great deal of that. And I anticipate that as whatever it is the letters may or may not tell us comes to light, I certainly expect that there'll be ongoing questions about both the workings of the Archives Act, the difficulties that many people have had in accessing material in recent years as resources and staff have been reduced. I mean, I've got, and I'm not alone in having examples of access requests that are now dating back 9 years, when the statutory requirement is that they're dealt with in 90 days. So, you know, that's an intolerable situation, but it's not uncommon. And nor is it uncommon in the sphere of Freedom of Information Act either, and access to documents there. And there have been other cases that have pursued that more strongly than I have. So I think there is a problem with some of the right to know expectations that might have existed, say, a decade or more ago. And I hope that the Palace Letters case and the richness of the documents once they are released, because really whatever they say, they're going to be extraordinarily important documents in understanding the history. I think that could well spearhead a revival of a quest for greater openness and transparency in terms of access to documents. I certainly hope so.
Mm. We've got some great questions coming in, Jenny, and we're trying to just collate them around ones that have the most support or interest or are replicated. So the next of that category comes from Roger Severn, who asks, Jenny, is the Queen the only key actor in the dismissal still alive?
No, that's an interesting question. Thanks, Roger. Look, I think one of the difficulties around request for access and the push to access these letters has to some extent been the fact that the Queen is still alive, and that there's a concern that whatever was being said on her behalf by her private secretary might not reflect too strongly either on the Governor-General, and that's certainly been the impression I've had from some, or for that matter, the Queen in allowing those conversations to continue secret from the Governor-General, secret from the Prime Minister. So I think that's been a concern. But no, Sir Anthony Mason, for example, is still alive, whose role we now are familiar with. And I did interview Sir Anthony Mason prior to releasing details of his involvement. He refused to comment on it. However, immediately after that material came out, he did release the only public statement he's made on it. And so we did draw out from him his acknowledgement and his additional comments, which was a good thing. Of the others, I think, no, probably most have died in certainly in recent years. And Sir Martin Charteris has died. The Kerr's official secretary, Mr. David Smith, as he was then, now Sir David Smith, is still alive. So I think they're probably the two main players, yes, who remain. And David Smith is somebody who I tried at great length to speak to, and who is one of, I think, only two people who repeatedly refused to speak to me. The other one was B.A. Santa Maria.
Right. Let me see. Stuart Hamilton, Jenny, makes the observation that one of the major criticisms of Kerr is that he did not advise or did not warn Whitlam. And he asks, do you have any sense that the letters might reveal whether the Queen may have suggested to Kerr he should or should not advise the sitting Prime Minister?
Very good question, Stuart. I think this is actually at the heart of what will be or can be controversial about the letters. There's no doubt that, as I indicated, that Kerr was not speaking to his own Prime Minister about these matters. No doubt that Buckingham Palace was aware of that. And I think if, as you've asked, if the Queen did not at some point remind Kerr of his most fundamental responsibility in a constitutional monarchy under the Westminster system, was that he must speak to his Prime Minister about this, then that is a cause for grave concern. So what you raise also points to the fact that there's going to be a real issue, not just around what the letters say, and matters like that are really critical, but also about what they don't say. Like, if that is not there in the letters, that tells us something extremely important. It tells us that the Palace, the Queen, the Governor-General are aware of particular events, aware of particular possibilities, whilst our government here is in the dark. That's really critical. And allied to that are some of the other points I think are very critical, or will be critical, in terms of what may or may not be in the letters. I've always felt very strongly that the single most important thing around the events of 1975 was the fact that Gough Whitlam was going to call a half-Senate election. again, no secrets about that. It had been the decision of the Labor caucus on the day that supply was blocked. It was announced in the media. If it continued to be a blockage in the Senate by the opposition senators and supply was not voted on, the half-Senate election, which was due at that time, it was the only election due at that time. And the government had decided that's the election to be called. And that's why Whitlam was at Yarralumla at 1 o'clock on the 11th of November. Now, I think a critical question is, what did he tell the Queen about that? Did he tell the Queen that the Governor-General was there to advise the half-Senate election, which he well knew because they'd agreed on the wording earlier that day. They'd exchanged the paperwork over the previous 5 days. What did he tell the Queen about that? I think the nature of Kerr's communications with the palace are going to be absolutely critical, and what is omitted from those conversations on both sides is going to be absolutely critical.
Jenny, this next one is pretty tricky, but it's popular. Sylvie Lieber asks, well, she says, Whitlam was the best Prime Minister in my lifetime. Why do you think the current Labor Party hasn't kept up Whitlam's wonderful heritage?
Oh, no, it is a tricky one.
It's tricky.
Look, I think all governments perhaps look... perhaps we're not as aware of the difficulties internally for governments once we look back on them, including Prime Ministers. Certainly Whitlam was very, very unusual, and he had, as you would know, a most remarkable reform agenda, an unheard of reform agenda, except perhaps going back to some of the developments of the 40s. In the Labor Party. So I think it's difficult for any Labor Party to reach back and be as widespread in terms of their reforms and their policy speeches as the Whitlam government. The thing that I realised with Whitlam working on his biography is that he was unusual not only as a leader with such a strong and determined agenda, but he was an unusually successful opposition leader. Because what he did during that time was to take a party that had been riven by the split of the 50s, riven by internal divisions over particular policy fields, and put together a manageable whole, which funnily enough included intervention in the Victorian branch. So, you know, to some extent history repeats in terms of trying to make an electable whole out of disparate groups and disparate policy positions. So he was very successful on that front. There were huge sectional interests against many of the developments. You know, we tend now to take Medicare and Medibank as it was then almost for granted. It's become such an accepted part of our social fabric and our health system that we're all so grateful for, particularly at the moment. But to call it a difficulty in getting that through is an understatement. The huge opposition to getting through the Medibank legislation is breathtaking. And even when I went back and wrote about that in a biography, I was absolutely shocked at how intense that had been, the deep antipathy, the false claims of socialisation of medicine, the vicious claims about Bill Hayden, who was the minister taking it forward successfully in the end at that time. Quite extraordinary. And yet Medibank as it was then, which was a universal health insurance system for all Australians, very quickly became, probably apart from the education changes, the most popular of all of the reforms of the Whitlam government. And Hawke, of course, brought it back in after Malcolm Fraser decimated it. So that's a long way of saying it's a difficult act to follow, and that's not a satisfactory answer. But I'm never as negative about politics as this might suggest, because even though I've spent a lot of time dealing with the great, what was a great tragedy, I think, both for Australia in terms of our policy positions, but also I know for so many people who worked at that time in achieving extraordinary things. Nevertheless, Gough Whitlam always said, maintain your rage and your enthusiasm. And he was such a strong believer in what he called the great Australian Labor Party, such a strong believer in the parliamentary system and a strong believer in being able to effect meaningful change peacefully through the parliamentary process, that I always maintain my enthusiasm and my hope that the political parties move in the right direction and that, you know, we have progressive change, no matter how slow that might seem at times.
I think you answered that very well. Thank you, Jenny, and we're so glad to have you as a distinguished fellow. Look, Jenny, there are a couple of questions coming in related to what access is going to mean. So I think Robert Allen and Natasha Lee Mays are both asking, what is access? Your access, what does that translate to in terms of public access and publication? Can you say a little bit more about that?
Yeah, thanks, Natasha and Robert, that's great. Yes, access is, because it's an unusual situation where access is being determined pursuant to a court case and pursuant to a particular order of the High Court of Australia. And that order is that the National Archives reconsider my application for access, which it had previously denied on the grounds that the letters were personal. So in the first instance, the Archives has to make a decision on that access and on my application. And in reaching that application decision, we're currently going through the process of possible redactions, as I mentioned. So that's the first stage. Once that is done, or at least no earlier than that is done, the archive, that means the letters are then, once they've been made available to me, the letters are then also publicly available. That's the way in which archives become available, is somebody requests them, they get opened, and therefore they are open for public access. In this instance, my understanding is that the letters are going to be digitised, and that at some point, not before they've been made available to me, but at some point that those digitised records will also be available online. So the public access follows from the opening of the letters pursuant to my application, which now has to be dealt with by the archives.
Thank you, Jenny. I have a question now from Seri Woods, who says, Jenny, the interests of historical transparency and accountability are at the heart of this matter. She asks, do you think that there are ever any valid reasons to conceal information from the public, or should full transparency always be the goal? What do you make of the potential for situations to be leveraged under the auspices of security?
I think we've moved too far in the direction of very vague. There are some rather vague wordings about the sort of things that can be redacted, and I'll only keep this to a discussion in terms of the Archives Act. I would like to see notions of affecting third parties, for example, tightened up a bit so that we're not able to use a catch-all clause for exemption as the basis for a broader exemption where it might not actually appear relevant. I think national security is one of the unusual ones where we have to recognise there are issues there. Again, I prefer if we take as broad a view as possible, but we have to recognise there are some areas in that. However, in terms of documents that are 45 years old talking about the removal of elected government, I'm not sure how national security claims could be made relevantly. The other point, I think the only real perhaps personal aspect that might be considered for redaction might be, for example, somebody's medical records, or, you know, if the Queen had the equivalent of a Medicare number, that sort of thing, you would expect that to be removed. But they're not matters really that get to the history. And the history in this instance is made up of the discussions, the one we're looking at, if we bring it back to these letters, the ones we're looking at are letters between two individuals where I gather from my conversations with others, many other people are referred to. There are many people mentioned in these letters, and that is the history. If any of those names are redacted, we are not able to fully understand that history. If any line in any one of those letters is redacted, we still don't have the complete history. So this is the concern, that the notion that because other people are mentioned and there may be embarrassment around that mention for them, or if they've passed away, for their families, I find that quite extraordinary. And yet it has been part of the general discussion out in the from some commentators about the sorts of things that might be redacted. That's the essence of the history here. The history is made up from knowing who is Kerr taking advice from, who is the palace taking advice from, are there other individuals politically, legally or otherwise that are in touch with these individuals and who perhaps played a stronger role than we're aware of. So I think once you start to get into those areas which are much less clear cut, that's where the difficulty may arise in the question of redactions.
Thanks, Jenny. Looking forward a bit now, we have a couple of comments and questions from John Wilson and Jackson Schultz, and I'll paraphrase Jackson's question. Do you think that the contents of the letters could potentially serve to bolster the Republican movement in Australia, especially if they show active involvement of the Queen? So questions around Australia's ongoing relationship with the United Kingdom and the role of the Queen.
Thanks, Jackson. Look, I think there's potential for that, certainly. Because if there's any way in which the palace is aware of the path that Kerr is considering, that's a deep and profound breach of the agreed relationship between the Queen or the monarch and the Australian government, which followed from the imperial conferences of the late 1920s and 1930 in particular, with the Balfour agreements that followed, because it set out very clearly that the Queen or the monarch, as it was then, was to have no role, no say in these sorts of decision making. So if there's any way in which, as Kerr relates elsewhere in his papers, that he had discussions with the Queen through her private secretary in terms of wanting some form of protection for his position as Governor-General, should he move to dismiss Whitlam, and it was in the context of the possible dismissal of Whitlam, that's clear from what at least he says in his journal. If that discussion was had, then that's a shocking breach. It's one which I think would and ought to call into question the continuation of Australia as a constitutional monarchy and a very fast-tracked move to a republic. It's utterly improper. So it also gets to the question, Jackson, of what constitutes active involvement. I think there's a move out there that, we ought to redefine the possible involvement of the palace into something active and immediate and direct, as in, as I've said many times, there is not going to be a letter saying, "Dear John, please sack Gough." That's not going to happen. So we're not looking at anything direct and obvious in that way. It's the entire notion of the Governor-General at such a tumultuous time in our history having lengthy, illuminating conversations with the Queen through her private secretary about these sorts of matters, including possibly the Governor-General's own tenure, that is so troubling, and that we need to see the letters to fully understand the extent of.
Jenny, I've got a very interesting question here from Lucy Taxa. She says, and I'm not sure if you're aware of this, there is currently a proposal by the New South Wales government to amend the New South Wales State Records Act 1998, which threatens to undermine government responsibility for appropriate record keeping and records management, as well as the reduction of funding for retention, with obvious implications for access and government accountability. Do you think that the Palace Letters case can have an impact not only on the administration of the Federal Archives Act, but also the administration of state archives acts around the country?
Thanks, Lucy. No, I wasn't aware of that, and that's a dreadful development if that's a case, if that's going to go forward. I'm not sure what stage that's at. Look, as I said before, I do think that the whole struggle to release these letters, and I include the general sort of commentary around it, not just the case itself, will and should have a bearing on the state archives, because of course I think it draws into question now the exclusion of governors' records from public access, again on the grounds that they're personal and confidential, which was the reason we were initially given by the archives for the withholding of the palace letters. So I think on that level it will certainly do that. But I think there's a real question now about the resourcing from a federal and a state level of government records, and there's been inadequate resourcing of the National Archives. There's been a steady decline in its funding. It's had to deal with funding cuts, resource cuts, and the difficulty there, of course, is that access requests get challenged by that, and access requests get dealt with very, very slowly, and we're all awaiting the release of the Tune review into that to see just what might be done and how those complaints can be dealt with. But I think there's a real push around the country away from the legislative requirements of the right to know and open access and open government, and that's where we are as a nation. I think we need to take a national approach to this that includes the states and the National Archives in calling for better funding, better resourcing, more staff. And unfortunately, with the situation that we're all in at the moment, I can't see that happening soon. But nevertheless, I think there needs to be a campaign around any attempt in New South Wales to make it more difficult to have access to documents for all of the reasons we've talked about today.
Sorry, Jenny, we seem to have lost Leanne.
Yes.
While we wait for her to come back, I'll just choose another question for you.
Yes.
This is from Alison. She asks, who do you think has benefited the most from the concealment of these letters, and in what way have they benefited?
Thanks, Alison. Look, I think the Kerr family perhaps has benefited, certainly the legacy of Sir John Kerr, such as it is. It's taken a bit of a battering in recent years because of other revelations. But I do think predominantly the palace. I mean, not just because of what the letters may say, that remains to be seen, as I've said, but because of this so-called Convention of Royal Secrecy, because that's been a Commonwealth-wide convention, and it's one that has been adhered to almost without question. And that's the extraordinary thing here, is that it was almost a reflexive response to the claim of royal secrecy, is that, oh yes, there's a Convention of Royal Secrecy, we won't open these records. And I don't mean just the archives with that, but that's been the case in all of the state archives, as I said, but also in all of the Commonwealth countries. There are 15 nations that may well be impacted on by this decision. That's the extraordinary strength of it, is that the claim of royal secrecy and the claim that there is an automatic convention that applies even in other Commonwealth nations, which is quite extraordinary, has now been dealt an end point, certainly in terms of the Australian Commonwealth record. So whether that is then used by others to try to access records in other Commonwealth nations remains to be seen, but I think it's certainly open to them. So I think in that broader sense, quite apart from what the letters may tell us about the particular time in our history and the particular event in our history, it's protected the fact that we haven't had access to the letters, and the use of the term personal has greatly benefited the royal family in general, the monarchy in general, from access that may follow to other records. And that's now, thanks to this case, overturned. And it's very, very rare to find a case that is able to challenge royal secrecy, for the simple fact that things are normally secret and you can't access them enough to get that question before a court. So this has been a rare case, and it's happened in Australia, obviously, but it has implications elsewhere. Some of you may recall only a few years ago, well, it was probably about 8 or 9 years ago now, but there was a long-running battle that the Guardian newspaper had over what were called the spider letters. These were letters from Prince Charles to British ministers, including the Prime Minister Tony Blair, which the Guardian had unsuccessfully tried to access through the British archives for many, many years. And they took a court case. It's not dissimilar to the situation we've just had with the palace letters. And they had a much longer struggle. It was a 10-year struggle, because at every point they won along the way. And at every point the palace, through the Royal Archives, contested that. And even though they were successful in the end and those letters were released, And lo and behold, what did they show? They showed the prince openly meddling or secretly meddling through letters to the government on matters of policy, completely improper, completely against what we are led to believe the royal family does not do, that is, involve themselves in domestic politics. And the British government at that point immediately passed an amendment to the Archives Act in the UK, putting a preemptive stop on the release of anything relating to the royal family, the next in succession, the one in succession after that, and up to 5 years after their deaths. So there is no way, there's now an ironclad grip over the letters and any materials relating to royal matters in the Royal Archives in England. And thankfully, we don't have any such archival structure here. We have a single archive, it's a public archive, it's our national archive, and we now can look at royal records that are hopefully all royal records in our archives, but certainly make an argument about looking more broadly than just the palace letters.
Jenny, did the governor, the New South Wales governor, consult the palace with regard to the 1932 dismissal of Premier Jack Lang, which was the first, albeit a state constitutional crisis?
That's a very interesting question, John. I have to say I'm not sure on that. I'll have to look that up. Those records, I imagine, would have been closed for a long time. But the difference, of course, with the Lang dismissal is that Game did warn him, and I think that's why there's never been quite the same degree of controversy about what happened at that time. And again, we come back to the requirement of the governor in that instance, or the Governor General in 1975, to of course speak to the head of elected government and to of course take advice. And if that advice is not going to be followed, then to warn, in that instance, the Premier what the repercussions of that may be. And that's what never happened in 1975. And even Sir Anthony Mason, following the revelation about his role, stated that he claims, Kerr did not claim this himself, but Mason claims that he warned Kerr that he must in turn warn Whitlam, that he must tell Whitlam of what he was planning to do, and he must give Whitlam the opportunity of going to a general election, which was not due at that time. He'd had a double dissolution, of course, just 18 months earlier, but to at least give him that option, or to speak to him frankly about his concerns. He did neither of those things. So yes, it's a very interesting question about whether the palace was, whether there was a discussion prior to that, but certainly one of the expectations, and I understand the general rule was, and remains today, that if something out of the ordinary happened, as of course that was with that dismissal, with the early dismissal, is that Game would have written to the palace and would have set out both his description of what had happened and his reasons for why he had done what he had done. And that's going to be one of the really interesting things about the palace letters, will be letters that follow the dismissal, because I think there's no doubt that Kerr would have and did write such a letter to the Queen afterwards, setting out what he'd done and why he'd done it. And he also makes a very interesting comment among his papers, where he says that he has had no doubt about the views of the palace on that matter, particularly because of correspondence after the dismissal. So that's going to be interesting. And the fact that he got the Queen's personal, one of her honours the following year, might have been a bit of a pointer to that as well.
Thanks, Jenny. And one last question. Can you tell us a bit about your next book? It's, as I understand, due to be launched later this year.
Yeah, thanks, John. Well, it is, as Leanne said, it's a book called The Palace Letters. And I want to thank Scribe Publications, which is publishing the book, and we're moving very quickly to get that out there. I'm trying to describe it as a political thriller, so it remains to be seen if it's possible to write what is effectively a legal case into a political thriller. But thankfully, I'm not a lawyer, so I don't have that drawback. It's taking the case really from I suppose from the very origins of the palace letters themselves, their location incurs, papers, the unfolding. It's an unfolding of what we find out about the letters, about the case itself, things that happened during the case, other revelations that came about only because of the case. You know, some of the more interesting, I think, legal questions around the Queen's apparent Convention of Royal Secrecy, and at the same time realising what the letters say, realising their great significance, and trying to build a sense of, I guess, excitement about the High Court decision that finally, after 45 years or whatever it is, allows us access to those letters. So, yes, it's a bit of a journey, but at the same time, it's revealing to everybody what the letters will say. And of course, the denouement of the book will be the letters and an understanding of the letters and how they now, or will, I imagine, change our understanding of the dismissal of the Whitlam government. So I'm looking forward to it. It's been a great pleasure to write it. And it'll be released in November, around the anniversary of the 45th anniversary of the dismissal of the Whitlam government. Very
good. Thank you very much, Jenny. Thank you to everybody for attending as well. I just wanted to apologise for Leanne. The internet at her location has apparently failed, so that's why she disappeared suddenly from our webinar. But it's been a great webinar today, Jenny, and I can only thank you on behalf of everybody who's concerned for Australian democracy's future, as well as trying to understand its past. It's really very important, and you've done us all a great service. And thank you very much to everybody that attended today. And I think we can wait with bated breath for what happens when the letters are finally opened.
Thanks, John. Thanks, everyone, for coming. And I look forward to talking perhaps once we've seen the letters. That would be terrific.
Thank you.